Employment law is the practice area where the legal advice and the human consequence sit closest together. A performance management process that has to be defensible and humane. A termination that has to be lawful and dignified. A workplace investigation that has to be thorough and quick. A policy that has to comply with the law and actually be read by the people it governs. The work is high volume, the mistakes are expensive, and the human cost of getting it wrong is something every employment lawyer carries with them. Employment Legal in the Claude for Legal release is the plugin that addresses the workflows that consume the most in-house counsel time and the most external counsel hourly fees in employment practice. Policy review, investigation support, Termination Risk Assessment, and Workforce Change Analysis. Each one is a workflow where the law is complicated, the facts are messy, and the partner's attention is the scarce resource that has to be allocated to the cases that matter most. The panel's view from the launch materials is that Employment Legal is the plugin where the playbook calibration matters most. Because employment law varies substantially across jurisdictions, the same fact pattern produces different outcomes in different states. And a plugin that does not understand your jurisdiction will produce confident answers that are wrong in ways that matter. The plugin's configuration question is doing heavier work in Employment Legal than in any other plugin in the launch. One integrity note before the walkthrough begins. The panel has not yet deployed Employment Legal on a live matter. The analysis here is built from the launch documentation, the GitHub repository, and the panel's collective employment practice experience. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base. Employment Legal opens with a cold start configuration that asks more jurisdictional questions than any other plugin in the Claude for Legal release. 15 to 20 minutes of setup, 4 sections, each one calibrating how the plugin behaves on the workflows you run most. The first section asks about your jurisdictional footprint, which states or jurisdictions you advise on, whether you have multi-state clients with operations across different employment regimes. What federal versus state overlay applies to your practice? The plugin uses this to set the default jurisdictional anchoring on every research output, which is the difference between a useful answer and a confidently wrong one. The second section asks about your practice profile. Are you advising employers, employees, or both? What industries do you concentrate in? What kinds of matters do you handle most? Performance management, terminations, workplace investigations, policy work, regulatory complaints, litigation, or some mix. The plugin uses this to set the playbook posture that drives every recommendation it produces. The third section asks about your firm or in-house team's standard playbook on the most common employment workflows. What is your standard process for terminating an employee under 50? What additional steps apply for a DEA-covered employees? What is your investigation protocol for a harassment complaint? What are your standard policy templates? The plugin uses this to populate the workflow templates that subsequent matters will start from. The fourth section asks about your active matter flow, the performance management cases currently active, the investigations in process, the litigation pending, the policy reviews underway. The plugin uses this to build the matter file that lets it carry context across workflows rather than reconstructing it each time. After the 4 sections, the plugin asks for 5 recent closed matters with their full file. The plugin learns from how your team actually runs employment work, which is materially different in every firm and in-house team, and the configuration alone does not capture that pattern. The panel walks through each of the 4 named workflows with the same 3 questions. What does the workflow do? Where is the gain most visible? And where, inevitably, do the gaps show up? The 4 workflows are policy review, investigation support, termination risk assessment, and workforce change analysis. Each one targets a different stage of the employment matter timeline, and the four together cover most of what the in-house employment counsel does in a typical week. Policy review is the workflow that runs continuously across the year, as policies are drafted, updated, and audited. Investigation support is the high-stakes workflow that runs when a complaint comes in and the clock starts. Termination Risk Assessment is the workflow that runs before every involuntary separation, calibrating the legal risk against the business need. Workforce change analysis is the workflow that runs when an employer is doing something at scale, a reduction in force, a reorganization, a relocation, an acquisition with workforce implications. The four workflows compose. The output of policy review sets the framework that termination risk assessment applies. The findings of investigation support inform both termination risk assessment and the workforce change analysis if the matter cascades. The plugin holds the matter file across all four workflows, so the counsel is not reconstructing context when moving between them. Policy review is the workflow most in-house employment counsel run continuously and never finish. Employee handbooks, code of conduct, anti-harassment policies, remote work policies, social media policies, drug testing policies, leave policies, accommodation procedures, and the 100 specialized policies that sit underneath them. Each one has to comply with current federal law, the law of every state in which the employer operates, and the employer's own historical practice. The work is constant. The stakes are high. The traditional pattern is that policies get drafted under deadline pressure, reviewed once, and then forgotten until a complaint reveals that the policy is out of date or contradicts a more recent practice. The plugin reads the employer's current policy library, identifies which policies are out of compliance with which jurisdictions, surfaces inconsistencies between policies, and produces a prioritized update list. The senior counsel reviews the list, decides which updates to make and in what order, and the plugin drafts the revised language. The counsel reviews the drafts the way they would review a junior associate's work and either approves, edits, or requests another iteration. The gain is the structural change in how policy maintenance works. Traditionally, policies get reviewed when something goes wrong, which is the worst possible time to discover the policy is non-compliant. The plugin reverses this. The review becomes continuous. The issues surface before complaints arise, and the counsel's attention concentrates on the strategic policy decisions rather than the mechanical work of identifying that a policy is out of date. The gaps come from policies that turn on specific operational context the plugin cannot see. A drug testing policy that depends on the employer's specific safety profile. An accommodation procedure that depends on the physical layout of the facility. A remote work policy that depends on the employer's specific technology stack. The plugin produces the legal framework. The operational calibration still depends on counsel who knows the business. Investigation support is the high-stakes workflow that runs on the clock. A complaint comes in, the employer's duty to investigate triggers, and the timeline from complaint to substantiated finding has to be both fast enough to be defensible and thorough enough to be credible. Counsel is balancing the witness interviews, the document collection, the credibility assessments, the preliminary findings, and the final report against a clock that the employer's culture cannot afford to let run long. The plugin reads the complaint, the relevant policies, the employee files for the people involved, and the documentary record. It produces an investigation plan with the witnesses to interview, the questions to ask each one, the documents to collect, the timeline targets, and the credibility assessment framework. As the investigation progresses, the plugin maintains the running log, flags inconsistencies between witness accounts, identifies where additional evidence would strengthen or weaken a finding, and produces draft findings the counsel can review and adjust. The gain is twofold. The investigation moves faster because the production work compresses. The investigation moves better because the inconsistency scan that catches the contradictions between witness accounts runs more rigorously than human-only review typically achieves under time pressure. The plugin does not make the credibility calls, the counsel does, but the plugin surfaces what needs the credibility call rather than burying it in the witness transcripts. The gaps come from the most sensitive investigations. Matters involving senior leadership, board-level complaints, allegations against the general counsel, matters with media attention. The plugin handles the factual record reliably. The political navigation, the communication with the board, the decisions about scope and counsel independence remain entirely the counsel's work and depend on judgment that no plugin can contribute to. Termination Risk Assessment is the workflow that consumes the largest single block of in-house employment counsel time. Every involuntary separation in a workforce of any size triggers a risk assessment process. Has the employee been performance managed properly? Are they in a protected class? Are there pending complaints? Is the separation timing problematic? What severance, if any, should be offered? What release language is appropriate? What jurisdictional considerations apply? The work is repetitive in shape, varied in substance, and consequential when missed. The plugin reads the employee's file, the performance documentation, the protected class status, any pending complaints, the proposed separation timing, and the business justification. It produces a structured risk assessment with the relevant legal risks identified, the severity of each one, the mitigation steps available, and a recommended path forward. The counsel reviews the assessment, makes the strategic calls about severance and release language, and produces the final recommendation to the business. The gain is consistency at scale. Termination risk assessment in a large in-house team typically produces inconsistent outputs because different counsel apply different thresholds, weight different risks differently, and draft different language for similar situations. The plugin produces a consistent framework that every counsel works from, with the variations being deliberate rather than incidental. The senior counsel can spot-check the lower-risk terminations and concentrate attention on the higher-risk ones. The gaps come from the cases at the edge, terminations where the business justification is weak, terminations where multiple risk factors stack in ways the plugin's training has not seen before. Terminations where the employer's broader strategy depends on the outcome in ways the plugin cannot evaluate. The plugin produces the risk assessment. The decision about whether to proceed remains the senior counsel's, and the cases at the edge get more attention rather than less. Workforce change analysis is the workflow that runs when the employer is doing something at scale, a reduction in force across multiple business units, a reorganization that affects reporting lines, a relocation that changes work arrangements for hundreds of employees, an acquisition that combines two workforces with different benefits, different policies, and different cultures. Each of these triggers a complex legal analysis with WARN Act notice requirements, disparate impact analysis, benefits harmonization, and policy reconciliation sitting alongside the operational work the business is doing. The plugin reads the proposed workforce change, the affected employee population, the relevant jurisdictional requirements, and the employer's prior practice. It produces an analysis with the legal requirements identified by jurisdiction, the disparate impact analysis on the proposed change, the notice and consultation requirements, the benefits implications, and the sequencing recommendations for how to implement the change defensibly. The counsel works through the analysis with the business, makes the strategic calls, and the plugin updates the analysis as the parameters of the change evolve. The gain is that workforce changes get analyzed before they happen rather than during them. Traditionally, counsel are pulled into a workforce change after the business has already decided what to do, which makes the legal analysis a constraint exercise rather than a design input. The the plugin shifts the timeline. The analysis runs during the design phase, which means the change gets shaped to be defensible rather than retrofitted into defensibility. The gaps come from changes with political dimensions, plant closures with community impact, reductions with workforce concentrations in specific demographic groups, changes that affect unionized workforces. The legal analysis is the lighter part of these matters. The labor relations, the public communication, the regulatory engagement, the political navigation, all remain the counsel's work and do not get easier because the plugin produced the analysis. I know what you are thinking. You are thinking that employment law is the practice area where the human element matters most, and that introducing a plugin into the workflow either dehumanizes the work or, worse, produces advice that is technically correct but lands wrong on the people it affects. The panel takes that concern seriously because employment counsel who have practiced for a decade have all seen what happens when the legal advice is right but the human handling is wrong, and they correctly do not want a plugin that compounds that risk. The answer is that the plugin operates on the legal analysis layer and explicitly does not operate on the human handling layer. The risk assessment for a termination tells you what the legal risks are. It does not tell you how to deliver the news, who should be in the room, what to say when the employee starts to cry, what to do when they ask for a reference, or how to handle the colleagues who watched the meeting from across the open plan office. Those decisions are still entirely the counsel's, and they depend on practice experience that no plugin can substitute for. What the plugin changes is the time allocation between the legal analysis layer and the human handling layer. The traditional pattern is that counsel spend most of their preparation time on the legal analysis and arrive at the difficult conversation underprepared on the human side. The plugin compresses the legal analysis work, which frees the counsel to spend more of their preparation time on the conversation itself. The legal work gets done faster. The human work gets done better. The employment counsel who have deployed the plugin well in their practice report that the most material change is not productivity, but presence. They arrive at the difficult conversation more prepared, more focused, and more able to handle whatever the conversation requires. That is the change to be honest about. The plugin makes the legal layer faster, so the counsel can be more present on the layer the plugin does not touch. The employment legal plugin handles complex employment matters with sophisticated jurisdictional intelligence. But the durable verification skills the panel has covered in the Foundation series still apply in full, and they matter more in employment work than in any other practice area covered by the Claude for Legal release. Verify every citation, from Foundation's number 6, applies to every regulatory authority the plugin cites in support of a recommendation. Employment law is the practice area where statutory and regulatory citations drive the analysis most directly, and the verification step is non-negotiable on every workflow that touches a filing, a position statement, or a litigation submission. The 5 Qs protocol from Foundation's number 7 applies to every legal research output the plugin produces. Employment law has substantial variation across jurisdictions, and the prompt-level discipline that constrains the plugin's outputs to your specific jurisdictional context is what prevents the most common failure mode in employment AI work, which is a confident answer from the wrong state. Build a chronology in an afternoon from Foundation's number 5 applies to every investigation, every performance management matter, and every termination where the sequence of events drives the legal analysis. The chronology methodology surfaces the gaps in the factual record that the plugin's first-pass analysis can miss when working from documents alone without the benefit of timeline construction. Step back from the 4 workflows and consider what employment legal does to the employment practice over the medium term, because the implications are different from the other plugins in the launch and deserve specific attention. The role of in-house employment counsel changes more than the role of any other counsel in the Claude for Legal launch. The traditional in-house employment counsel spends most of their day on production work that does not require their seniority: policy reviews, routine risk assessments, run-of-the-mill terminations. The plugin absorbs most of that work. The seniority of the counsel remains essential, but the work that occupies their day shifts substantially. More time on the investigations that matter, the workforce changes that have strategic implications, the relationships with business leaders, the development of more junior counsel, and the strategic positioning of the employment function inside the company. The economics of the external counsel relationship change too. Employers have historically used external counsel for the policy reviews and routine matters that the plugin now handles in-house faster and cheaper. The external counsel relationship shifts toward the matters that justify external rates: the litigation, the sensitive investigations, the matters with regulatory exposure, the bet the company workforce changes. Law firms whose employment practices are built primarily on routine work face a meaningful business model question. Law firms whose employment practices are built on the high-end work compound their advantage as the routine work migrates in-house. For senior employment counsel with the seniority and the context to deploy the plugin well, this is the most material change to employment practice in 15 years. The work compresses on the routine end and expands on the strategic end. The practitioners who recognize the shift early are the ones who will be best positioned when the rest of the market arrives at the same understanding 2 years from now. That was the walkthrough. The 4 named workflows in the Employment Legal plugin, the jurisdictional configuration that shapes how the plugin behaves on every matter, the insight that distinguishes how the plugin changes employment practice from how the launch marketing describes it, and the strategic implication for the function of employment counsel over the medium term. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base. That episode will name the failure modes the panel finds in practice, rather than the ones anticipated from the launch materials, and the panel expects the jurisdictional anchoring to be where the most unexpected behaviors emerge. The unpacked launch arc continues. Episode number 8 covers the privacy legal plugin, the practice area most affected by the cross-border regulatory complexity that the plugin's jurisdictional anchoring is designed to handle. The arc then closes with product legal and AI governance legal as a paired episode, and the document layer connectors in episode number 10. If your practice touches employment work in any meaningful way, the Employment Legal plugin is one of the most material changes in the Claude for Legal release for in-house and external counsel alike. Adopt it carefully. Build the jurisdictional configuration with precision. Maintain the playbook as the plugin runs. The lane is moving fast, and the firms that move with discipline now are the ones that will be best positioned when the dust settles. That's the episode. See you in the next one.